Hey everyone, Dan McKenzie here, the McKenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm in the Denver, Colorado area. And thought I'd make a video about something that a lot of people overlook, but it's actually critical, which is debt owed by a person who's passed away. And so a lot of people have questions about, someone that did owe money to people, who's responsible for paying that. And people always, when you pass away, there's always somebody's owed money, right? I mean, even if it's just the last cell phone bill coming in, the last water bill, final expenses, of course, but it can be much more extensive than that. A lot of people pass away after hospital stays, sometimes extensive, sometimes with the most expensive medical treatment that you receive is kind of end-of-life care, unfortunately. So hospital bills can be quite big. There can even be lawsuits, right? If somebody passed away in a way in some sort of accident that injured or killed other people, there might be lawsuits going back and forth over that. And so debt is, it's interesting. It's something that a lot of, I think people are overlooking as part of the probate process. And especially on the planning side, when we're putting together a plan, I always point out to people, like, one of the most important things that your personal representative or trustee is going to have to do is going to be to identify debt, figure out, what can be paid, what has to be paid, is there sufficient funds to pay whatever debts are out there. People are always thinking about the kids or the beneficiaries, the people named in the will, the spouse, of course. That's critical. It's obviously, like I say, it's on the forefront of people's minds when they're doing planning, but just as critical when we're doing an estate administration is notifying creditors and getting those things figured out correctly, because the personal representative has a duty to those people too. And if you're owed money by somebody who's passed away, of course, you want to have a fair shot at getting that debt paid before the family runs off with everything, especially if there was sufficient money to pay that debt. So I always, when I'm talking about estate administration, just I like to note that creditors are there, and really there's kind of two general types of creditors. So I'll do my whiteboarding here. So we got, let me undo that. Let's see here. Do it a little bit neater. Creditors. And you've got, like I say, two general types. One is known creditors. Right? So you've got, like I say, when someone passes away, like, bills are coming in. And if you're the personal representative, one of the first things you should probably do is divert that person's mail to yourself. And there is a process for doing that. Usually it can vary a little bit by your post office, but talk to the post office where that person was residing and see about having their mail forwarded to you. Sometimes they need some proof that you actually are entitled to receive that and are an agent for the person who passed away. So there can be a little bit of process there. But any bill that comes in after someone has passed away, of course, is a known creditor, right? You can't, that person does not have to hire a lawyer, make an appearance in the probate case, file any official form with the court or anything like that. If they've sent a bill and the personal representative has gotten it, they are now a known creditor. And then the other type of known creditor out there is, like I say, if the person passed away in a hospital, for example, or if you know that there is litigation has been threatened or something like that, those people are arguably known creditors too. And so, you probably, in a lot of circumstances, you actually need to kind of affirmatively reach out to people and let them know, hey, I know a bill is coming. I'm the personal representative of this estate. Send it to me. And that doesn't mean by any means that you're necessarily going to pay it. There's a lot of considerations that go into that, but you do need to let them know where that bill needs to be sent. So known creditors, you have certain obligations to those people, and then I bet you can probably guess who the other general type of creditors are out there. There's possibly unknown creditors. And so maybe the best example of this is like family loans, right? So if the decedent borrowed money from somebody, either a friend or a family member, there might not be any public record of that. It might not even be a written record, but if they've executed a note, even in those circumstances, that note just might be sitting in a filing cabinet somewhere and not necessarily known about by anyone other than the lender and the borrower. So to deal with that situation, these people, if there's a probate process, we will actually run a newspaper ad in Colorado 3 times over 3 weeks if the probate has been open within a year of the person passing away. A big message to take away about creditors is there are notification requirements. They are different for the different types of creditors. They are different depending on how much time has passed since the decedent passed away. So sometimes probates don't get open right away. Sometimes people think there isn't going to need to be a probate. They don't find out for a little while later. So sometimes we've opened probates years later. If you look at the Colorado statute, it does say probates are supposed to be open within 3 years of a decedent's death. But sometimes circumstances come up where we didn't even know the person had an asset. Mineral interests sometimes don't get found until a check shows up, and suddenly there's minerals being fracked or something like that were dormant for years. We've had situations actually where lawsuits did not become apparent for some time afterwards, and so sometimes probates are not open, and so your obligation to go through these processes is really dependent on how long it's been. A year, if there's been a year past and nobody has notified anybody about any debt being due, arguably that is those debts are extinguished, and so sometimes we will actually use that if we're real worried about whether a state has sufficient amounts to pay. We might hold off on doing certain notifications, but that really should be done under the guidance of a lawyer because, again, the formalities required for a creditor to actually notify somebody about a debt are pretty low. And so you don't want to end up in a situation where you've distributed assets, you've done a probate process, and then sometime afterwards somebody shows up and says, hey, I was a known creditor, and you with reasonable effort you could have found me and notified me directly, and so you were obligated to do so, and so personal representative, you need to go get that money back and pay me. And if you can't do it, potentially, depending on the circumstances, the personal representative might have personal liability there. So just a lot of ways to a lot of landmines here. And so just got to be very careful. But we got a newspaper ad for unknown creditors 3 times over 3 weeks. And again, even within that, arguably, there's a little bit of variability as far as, okay, what does 3 weeks mean? If I run one ad on Sunday and the next ad on Monday, have I covered 2 weeks? Depending on how you read the statute, there might be ways to kind of compress that time period. But we run that newspaper ad, and then after this has happened, the creditors have 4 months from the time that the ad started to run to actually make their claims. And so a probate process in Colorado has to be open a minimum of 6 months, just to give the beneficiaries, creditors, any interested party a reasonable chance to find out about it. But this actually will also affect how much time the probate has to be open, because if you don't do that notification for a while after opening the probate, this could extend that time out. And so and then the known creditors, again, they're given a deadline too to say, hey, I've sent you this notice to let you know if you have a claim, let me know, and they only have until this deadline actually too. And so there's a little bit of, again, calculation there as far as when are we sending out these notifications to known creditors, so that we can kind of try and minimize the amount of time. I mean, obviously, like I said, a personal representative has to be fair. They have to follow these rules. They have to they have an obligation to be upfront and all that with any creditors. And like, as I've been describing here, there's all kinds of rules about how those notifications have to be delivered, and under what timing and all that stuff. So you got to be very careful with this. But obviously, we're trying to do what we have to do to meet those obligations, but maybe minimize the chance that creditors are going to find out if we think they might not. So we're generally not running these types of ads like in the major newspaper, like the Denver Post or something like that. We're typically picking more kind of regional papers that might only print in the county that we're dealing with. So again, there's minimum circulation requirements, has to be published a certain amount of times, has to be reach a certain amount of people. And so you can't, it's not like you can publish this in, your HOA newsletter or something like that. So, at the end of the day, the question that really prompted this video is like, who's responsible for this debt? Well, typically it's the estate, and if the estate can't pay it, that's the lenders are, especially professional, sophisticated lenders like credit card companies or banks or whatever else, like they're aware, like, if someone passes away, I might not get paid unless I've got like a co-signer or some other security interest. And so there, it happens obviously a lot where, the family could have paid it, but it's not their debt. It's the estate's debt. And so at the end of the day, we do have to go through a process here to make sure that the debtors or the creditors have a fair chance to find out and make their claim and all that kind of stuff. But in most circumstances, unless the family has taken on some sort of obligation there, or there is a security interest, it really should just be the estate. And if the estate is insolvent, meaning that it does not have enough cash to pay those debts, then there's a process that's called the formal probate process, where we can actually have a court hearing where different creditors will make their case as to why they should get paid. But a lot of times there's some negotiation there too, where people will be told like, look, you might not get anything, so why don't you take this reduced amount? But that can get that again. This is all. It argues in favor of why using an attorney to help you with this process might make a lot of sense. If you're just cutting things in half and giving them to two kids, that might seem very straightforward. But we've seen a lot of situations where the beneficiary side of the estate is very straightforward, but the creditor side turns out to be more complicated than we ever would have anticipated. It's very hard to predict how this might go once you go into the probate process, because when you're doing these notifications, we don't know what's going to turn up sometimes. And a lot of probate processes, assets get found that weren't known about, and so do debts. And so making sure, like I said, making sure you've gotten this right is critical for the family being able to move on with certainty and know that there isn't going to be some period down the road where some creditor shows up and says they weren't properly notified. That's the nightmare scenario. So, hope this is helpful. Like I said, this is important, and people often overlook it. So, if you're a personal representative, or if you're a family member wondering why money hasn't gotten out to me, this might be delaying things. It's again, the personal representative wants to be very sure they've done this correctly before distributions get made. So, this can kind of hold things up, and it might be, in a lot of circumstances, it's the right decision to wait. So you got to be patient. So so if we can further guide you on anything involving a Colorado estate, we'd be happy to talk to you about that. Again, we're the McKenzie Law Firm. Our phone number is 303-578-2745, and I appreciate you watching, and I hope it was helpful. Thank you.